Hello, this is Matt on the Moon Lambo channel, and here's a headline from Cointelegraph. SEC Commissioner says safe harbor laws would have made ICO problems worse. This is a topic I've talked about on and off for years on the channel. Like, honestly, even before the SEC went after Ripple, this is a topic I've been talking about because there clearly is not sufficient regulatory clarity. But there is a proposal that would allow for new cryptocurrencies to be launched and come into compliance with securities law over a span of a few years. Now, technically, if this were adopted, that would mean that by the nature of going through the guidelines of whatever's included in the safe harbor, they would already be in compliance just by doing that. But really, the broader point is that they'd have to hit certain benchmarks, thresholds for decentralization in order to continue to exist in the way that they are. And so ultimately what happened here is one of the 5 commissioners here is very against Hester Peirce's safe harbor law, or her proposal, and it's just, I hate to see it. You really hate to see it because Hester is absolutely on the right path, charting a path forward for the crypto space. Because, you know, if this existed, this is something that if it had existed many, many years ago, this would have saved Ripple from the SEC. Because, look, if this exists, that means that there's clear guidelines. But this commissioner says no, and that it's dangerous. This commissioner in question, her name's Caroline Crenshaw. So I'm going to run through this article here, and I've got a bunch of stuff to say about this. Also, Hester Peirce saw that Caroline Crenshaw, her colleague here, one of the SEC, one of 5 commissioners, not so fond of this, and she commented on that. And so did Ripple's general counsel, an attorney named Stuart Alderati, who I highlight from time to time on the channel. And also, Attorney John Deaton's crypto law organization chimed in on this as well. So, plenty to talk about. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I am just an enthusiast who makes crypto-related YouTube videos all up on the internets, but just as a hobby and just for fun. That's all that's going on here, damn it. All right, so let's go ahead and dig in. Caroline Crenshaw, a commissioner at the United States Securities and Exchange Commission, has said the safe harbor proposal would have exacerbated the problems seen during the initial coin offering boom of 2017 and 2018. Let me pause here to note the significance of this in case you are unaware. There are 5 commissioners at the SEC. That's it. Just 5 of them. And the 5 of them vote on whether or not to bring legal action against individuals or entities. And so this is highly consequential. You can get into the minds of the people that voted. Like, this is one of the individuals that voted on whether or not to bring the legal complaint against Ripple. I'd be willing to bet, based on the way that she's talking here, that she was probably somebody that voted in favor of that. And it really is a shame. It's just, there is no path forward here. And so anyway, Crenshaw made the remarks during the annual SEC Speaks event this month and posted her speech to the SEC website on Tuesday. The commissioner argues that the impact on investors and markets would have been far greater if safe harbor provisions were in place at the time. And this is an astonishing take on this, but here's the quote from Crenshaw. I think the results would have been even worse for investors and the markets. ICOs and other digital asset offerings raised billions from investors, but most never delivered on their promises. Investors suffered the losses. Look, any entity that wants to launch a cryptocurrency, you know, it doesn't mean that you let all of them in just because safe harbor exists. You still get rid of the scams, this and that. You can have barriers to entry. We're not saying that something like that can't exist. We're just saying there needs to be a clear path forward to decentralization. And this is key because without the centralization aspect, any new cryptocurrency that ends up getting sold, there's going to be a claim that that's a common enterprise, which is a prong of the Howey test, which means that you're selling an unregistered security. Everything's going to get sued into oblivion, which is why if this case doesn't go well for Ripple, the SEC versus Ripple case, like, if XRP is a security, so is everything that's not Bitcoin. Hell, even maybe Bitcoin is. I mean that. Like it's that bad and it's that serious here. But I don't think if you had rules of the road that everything would have been disastrous. And then on top of that, this is another perspective that I hate about this. The fact that a bunch of these platforms that promise to do so and so, well, maybe not all of them should get recognition from the SEC necessarily, but I still hate this idea that the government is thinking it's their job to let me be careful here. I think it's okay for them to protect from outright scams, this and that. I don't have a problem with that. What I have a problem with is the government, in this case the SEC, picking winners and losers here, because they don't know which of these platforms are going to deliver on their promises and find success and actually gain adoption. And so if you're an investor jumping in, there is risk, and a lot of them are going to go away. And you know what? Most businesses actually do fail. Did you know that? Most businesses fail. The strong majority of businesses that come into existence, they stop existing after a matter of years. Like, look up the stats. I don't remember off the top of my head, but for the United States, I actually used to know them quite regularly, especially after because I'm a business owner. I've owned my own company for almost 12 years at this point. In January, it'll be 12 years. Most businesses fail, right? And so the fact that most of these platforms don't deliver shouldn't be surprising, but it's not your damn place to come in and say where people should be able to invest their freaking money. Yes, protect them from outright scams. I don't have an issue with that. But there's no clear path forward here. This is a bad take. This is a bad take from Crenshaw. And here's another quote. And I think that it is not a coincidence that these problematic offerings predated and continued through the beginning of a multi-year downturn in the value of digital assets, sometimes known as the crypto winter, she added. So if she's aware of crypto winter, then is she not also aware that in terms of price action, all cryptocurrencies move in tandem anyway? Whatever. They're not going to admit that. Admitting that wouldn't help them with their Ripple case anyway, right? The SEC versus Ripple case. Anyway, the safe harbor proposal has been advocated by crypto-friendly SEC Commissioner Hester Peirce. The proposal seeks to grant network developers a 3-year grace period to build a decentralized network without fearing SEC legal action, but has yet to be embraced by most of the other commissioners. Peirce, or Crypto Mom, put forward a revised version earlier this year in March. Cointelegraph reported on October 5th that North Carolina House Representative Patrick McHenry also put forward a 3-year safe harbor proposal in a draft bill of the Clarity for Digital Tokens Act of 2021. Yeah, so look, the only people that don't want the safe harbor are the people at the SEC that just want to keep the status quo. They want to maintain their power, and not just maintain it, but grow their power. And so they look down on you because they feel like you're too stupid to get your shirt on in the morning by yourself. You need assistance. That's how they look at you. You are too stupid to make your own financial decisions. They need to come in. You got to hold their hand, and they'll make sure that you're not abused. That's it. And meanwhile, the accredited investors out there, they get to take advantage of low liquidity environments when it's cheaper to purchase particular assets, whether it's a particular stock or a cryptocurrency, whatever it is. They get the treatment. And why? What makes them accredited? Well, they're sophisticated because they already have money. That's what the barrier to entry is at that point. You have to have a high net worth or be making hundreds of thousands of dollars per year, and then you can become an accredited investor. I hate the way that this is approached. These people talking down to you like you're a damn idiot. I mean, it's offensive, right? It's insulting what they're saying here. That's what I'm saying. Anyway, Crenshaw argues that instead of pushing the crypto sector toward compliance, the safe harbor proposal would put investors' capital at further risk, as crypto tokens would be deemed outside of the jurisdiction of the SEC for several years. So let me pause right there. Not true. It doesn't mean that you can run rampant and just have completely Here's the thing. What we're talking about here, not that I want the SEC to oversee as much as they do, but if what we're talking about here is full disclosure about various ways that whatever the entity is going to market this and that, like that's what we're talking about. In order to be compliant, it's not that an entity launches a coin and then without speaking to the SEC, it falls under safe harbor. You'd still have to speak with the SEC and get registered within that. But the SEC should push for that, is what I'm saying right here. And So as far as this, adding additional risk to investors, no, that's not what this is. That's absolutely not what this is. It's an opportunity for these types of new entrepreneurial endeavors to come into a position where they're decentralized over a span of years. That's really what we're talking about here. And so the idea of a company coming to market, being transparent, engaging with the SEC, and then becoming decentralized over a span of a few years, that is not dangerous for investors. If you have a bad implementation of it, maybe, I don't know what that would look like, but that in and of itself, the idea is certainly not dangerous for investors. And so here's another quote from her. I also worry that relaxing regulatory requirements in markets prone to investor protection failures, limited investor redress options because of pseudonymity and disintermediation and market manipulation cannot sustain investor confidence or yield lasting broad adoption. Well, I'd still say, I'd start with this point. That should not be any of their damn concern. It's none of your damn business with the risks that I want to take. But even if we're going to say that the SEC should have a say in that particular stuff, there's a way to go through some sort of vetting process, this or that, because you have to be transparent, I mean, think about what it takes to have an initial public offering and be publicly traded you have to have the SEC's approval. Well, there's still a vetting process. It's not that you can't have something like that. That's why this is a really bad take. I really don't like this at all. Anyway, piece continues. Instead of a safe harbor, Crenshaw called for a bridge in which token issuers and other crypto firms work with the SEC to outline plans for regulatory compliance or discuss specific exemptions when they are deemed appropriate. And here's a quote. I believe that if market participants accept proactive responsibility for compliance, we can build a bridge that promotes innovation while preserving market integrity and providing the investor protections needed for these new markets to grow. If you likely fall within our jurisdiction, work with us to describe your plan to comply or explain why some exemption is appropriate, she added. Okay, and so Stuart Alderati had something to say about that. Stuart Alderati is general counsel at Ripple, over 35 years of legal experience with expertise in banking, regulatory affairs, and complex litigation, as he describes himself here on Twitter. And he wrote the following about this. Appreciate the sentiment of bridge building, but, number one, many have embraced compliance, and number two, seems like the only reward for cooperating with the SEC is an enforcement action or threat of one. But good to know Commissioner Crenshaw is at least reading crypto Twitter. Yeah, that's a good take. That's exactly correct. And then there's this from SEC Commissioner Hester Peirce, who has written the proposed safe harbor law. And she wrote, I'm happy my colleague Commissioner Crenshaw thought about the safe harbor, but I'd be happier if she thought about it differently, as a way to achieve valid investor protection goals without inhibiting the development of user-controlled networks. And so there it is. Also, I've got, where is it? Oh yeah, here it is from Crypto Law. This is John Deaton's organization, Crypto Law. Crenshaw doesn't acknowledge that firms that take proactive responsibility for compliance are being punished and investors with them. Yeah, isn't that convenient? Has the SEC shown one bit of good faith yet to any firm that took this advice? If so, nobody seems to know about it. And that's a good question. I've actually been wondering that. Is there any firm operating in the blockchain space that spoke with the SEC and ended up getting something out of it? There's some sort of advancement and clear path forward. Is there one example of that? I'm not aware of it. If there is, fine. But that would be the outlier case. I don't even think that there's an outlier case, though, to be honest with you. Let me know what you think, but I'm wrapping up here. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.